Good morning. For those of you who I have not had the pleasure to meet yet, I'm Tawny Alvarez. I am a partner in Verrill's Labor and Employment Practice Group. I and Rob Brooks would like to welcome you to Verrill's first ever virtual annual update. I know a year ago, neither he nor I were expecting to be hosting you all from the comfort of our home offices. But we've made this decision to ensure that everyone stays as safe and healthy as possible. Additionally, because we know sitting on Zoom all day long can be absolutely exhausting, we've taken our traditional day-long event and we've broken it up into hour-long sessions on the third Thursday of each month, with each session covering different topics relevant to employers. Before we get started, a few housekeeping items. Your lines have all been muted to avoid any interference. Please submit any questions you may have concerning the content of the presentations through the Q&A feature at the bottom of your screen. We'll do our best to answer those questions throughout the course of the program or as time allows at the end. We also have dropped a link in the chat, which will bring you to a downloadable slide deck with certificates of attendance for Massachusetts CLE and SHRM credits. This morning, right now, we have the Massachusetts update. Earlier today, we did the Maine update, but we welcome all participants to stay and to listen in at 1 o'clock to the Connecticut update, should you have employees or operations in Connecticut. If you are joining us for those additional sessions, we'll note that the Zoom link is the same all day for all of today's programs. You don't need to sign out. You can if you choose to. And if you do hop out and hop back in, you're going to use the same link. Lastly, the next session of our annual update series is going to take place on February 18th, and it's going to cover joint employers and independent contractors. And with that, we're going to get started, and I'll turn it over to Rob, and we can go to the next slide.
Right. Tony, I'm Rob Brooks. I'm a partner in the Labor and Employment Group at Verrill Dana, and I've been doing this annual update with the firm for I think maybe 25 years now. I remember being a rookie associate a long time ago and being thrust out in front of the crowd. This is, as Tony said, our first virtual annual update, which is typically a day-long affair, and we miss seeing you all in person. And to those of you I haven't yet met, hello virtually. I look forward to a chance to see you personally in the not too distant future. So this session today is essentially what usually is the first session of our day-long annual update. And it's generally a grab bag of issues that are topical, that we aren't otherwise covering later in the day. And in this case, I guess topics we aren't otherwise covering in the following months. So the third Thursday of each month, yes, stay tuned, and we hope to see you again then. So this first session is generally heavy on updates with respect to legislative decisions or pieces of legislation, court decisions, and the like. Here, however, we're going to weave in something that's very topical, namely COVID-19 vaccine mandates. That's going to take up probably the first 20 or so minutes of this session. In some respects, we wanted to get this in because it's very timely. We're being bombarded with questions from clients about vaccines, vaccine mandates. Do you have to pay for the time for people to get them, or should we mandate them? Shouldn't we? There's lots of questions, and it's not something that most HR representatives, or we for that matter, have really had to deal with in any depth before. So we think it's worthy of talking about it today. So with that, I think we'll go to the next slide. So COVID-19 vaccines, boy, this is it's a real hot topic. I mean, you can't open a newspaper or turn on the television and haven't been able to in the last 10 months without being bombarded with this topic. Probably is worth recognizing, and I think most people would admit, that the pandemic has people in a pretty heightened emotional state. There's a pervasive sense of fear, anger, depression, fatigue. A lot of people are on 11 with respect to the pandemic, and in particular, vaccines is, that's one issue in addition to masks and lockdowns. It really is generating a lot of attention, a lot of energy, a lot of controversy. And so this is something that I think is worth paying close attention to because when there's controversy, there's tension, litigation, and other legal battles often ensue. So, what's the issue with vaccines? Well, it's pretty controversial. Why is it controversial? Well, it essentially is a conflict between public health goals and individual freedoms to refuse a medical procedure. Sort of informed consent is one of those bedrock principles of medicine. If people have a right to refuse a medical intervention, and I think it's worth noting that at least some people would view a vaccine as a medical procedure. It's immunotherapy. And it's intended to have a long-lasting effect on someone's immune system. So I think it's helpful to look at it in that perspective to help understand those people who may have some concerns about them. So speaking of concerns, there are some pretty significant pockets of resistance to vaccines in this country, even before COVID hit. And in particular now with this pandemic, the COVID vaccines have received an extraordinary amount of attention, more so than ever before. And I'm not sure it's fair to say that it's just a political orientation issue. People who are Republicans are concerned, people who are Democrats are for. I think that the concerns are straddling party lines. I mean, you don't have to go back more than a couple months before the election. You had Vice President Harris say that she wouldn't take a vaccine recommended by President Trump. But yet now she's taken the vaccine. And so I think there's some mixed messages that people are perceiving in all areas, all industries, including healthcare workers. I think a recent news report said that in California and certain healthcare facilities, 40% have declined the vaccine. But in the Wall Street Journal earlier this week, they reported that a survey of New York residents said that 26% of them were not going to get the COVID vaccine. And that's consistent with even US polls nationally, that a similar percentage, 26, 27, 30% of the population is not going to get the COVID vaccine or is going to wait a long time. So that's, I think, something employers just have to deal with. And, and again, what are people basing their concerns on? Well, one of those issues are concerns about adverse reactions. I mean, some people have said, well, it's rushed. We don't know if it's going to work. And again, we're getting data that the current vaccines that have been approved, the Moderna and Pfizer vaccines, are very effective, 95% effective. But there are stories about adverse effects that are emerging. The CDC reported that in the first week of the Pfizer vaccine rollout, they had 5,000 adverse reactions reported. And it was a very broad description of that's an adverse reaction. Is that just a sore arm, a headache, nausea, or is it being in intensive care? That's sort of a grab bag. So they had a very broad definition, but still 5,000 adverse reactions were reported to the CDC in the first week, including some pretty severe reactions in Alaska. There was a nurse who was in intensive care for 2 days. Just last week, the New York Times reported on an obstetrician in Florida who died of an autoimmune disorder that, according to the New York Times article, there's an expert from Johns Hopkins who said that was absolutely caused by the vaccine that essentially destroyed this guy's platelets, and they couldn't reverse that condition. So and then just even this week in California, the state epidemiologist in California has recommended that a hold be placed on a particular lot of Moderna vaccines, 330,000 of them, following a string of about 6 to 10 allergic reactions within the 15-minute window that people wait to see if there's a reaction of healthcare workers down in San Diego. So because of that seemingly large number or unexpected number of adverse reactions, allergic reactions, they said that maybe we got a bad lot. And so they put a hold on that lot of 10% of the state's supply, which I read just about 15 minutes ago has now been lifted. So that lot of Moderna vaccines is now being put back into use, but it may not necessarily allay the concerns of those who are, lined up in San Diego or elsewhere to get their shots. That geez, has the problem been taken care of? So there are some concerns out there about side effects, and so it's worth at least acknowledging they're out there, even if they're unrelated or unfounded. So I think that the reality is that, again, people are on a very high level of agitation, on all sides. People should get the vaccine, they shouldn't get the vaccine, and so, or people should wear masks, they shouldn't wear masks. I mean, it's a very emotionally charged environment. So why don't we go to the next slide and just talk about what's the current landscape. So the current landscape on vaccine mandates is that currently at the federal level, there are no mandates, not yet anyway. With public health and safety, that's a topic that has generally been left to the states under our US Constitution. So under the police powers of the states, they are responsible primarily for the public's health and safety. And so vaccines certainly fall into that. So states have taken a variety of approaches to dealing with vaccine mandates. In general, however, how much latitude do states have in exercising their discretion? And the answer is, for the most part, has been they got a lot. And thanks to a Massachusetts case from 1905, Jacobson versus Commonwealth of Massachusetts, the U.S. Supreme Court upheld the right of the state, and in this case, it was the city of Cambridge, that mandated that people take the smallpox vaccine because of an outbreak in Cambridge. And an immigrant from Sweden, Mr. Jacobson, had had a bad experience back in Sweden with the smallpox vaccine, and he said, I don't want it. And he was fined $5. That was the penalty for not getting vaccinated. And he took that case to the United States Supreme Court, which said that the city and state, Commonwealth, had the right to mandate a vaccine in the course of their police powers. That's within the scope. But that's a really old case, and the concept of individual liberties relative to the power of the state has evolved over time. Roe v. Wade is a pretty good example of that evolution. And so the courts, I think, are starting to take a harder look at Jacobson, and they may be paring back the state's ability to exercise their police powers when it comes to individual liberties otherwise guaranteed by the Constitution. And I think we saw this very recently, about a month ago, when the Supreme Court struck down some rules in New York that limited the number of people who could go to a church service or a synagogue. And the majority opinion, which was a per curiam, but there was no author to it, basically said the state had overreached. There was no rational basis to distinguish between the Walmart, which had no limit, and the cathedral or the synagogue, which had a limit of, I think, 10. So in the concurring opinion written by Justice Gorsuch, he actually went to the trouble of discussing Jacobson, and he essentially was saying that that's a pretty narrow case as he reads it, and that maybe it doesn't necessarily give the states as much latitude as everybody has assumed they've had. And so with this current makeup of the Supreme Court, I think people ought to be aware that Jacobson may not be as solid a case as it once was perceived. So what are the states doing with respect to vaccines? Well, they're doing a lot of different things, but right now there's at least 9 states that are trying to prohibit discrimination based on vaccinated status. So, and that's not just for employees, it's for customers or any other person you deal with. So that's 9 states, and some of them, like in Minnesota, they're going to make it a felony or trying to if somebody tries to discriminate on the basis of someone's vaccinated status, including COVID vaccinated status. That's sort of the focus of these bills. New York State sort of taking the opposite tack. They have a bill right now that would mandate the COVID vaccine for citizens if the number of people who get the vaccination in that state isn't high enough per public health authorities to reach herd immunity. And it actually interestingly, in New York, the State Bar Association actually went to the trouble of endorsing this very recommendation that they think it's legal for the state to mandate the COVID vaccine, and they cited the Jacobson case, by the way. So it's quite interesting that this 115-year-old case from Massachusetts is now sort of at the middle of this brewing storm as to the limits of the state, or the rights of the states to impose COVID vaccine mandates. So the next slide, please. So what's going on in Massachusetts? Well, right now, there are no COVID vaccine mandates for the general public, and no bills pending, at least that we could find as of this week. It doesn't mean there won't be, certainly, and I would say it's entirely possible that the Commonwealth will decide to get into the action here. One area that they actually have sort of dipped their toe into, and this is through regulation from the Department of Public Health, and they issued a rule in October directed at assisted living facilities. So it's pretty narrow, but they said that in health screening, or they lay out these health screening requirements for employees at assisted living facilities. And I've quoted it from for you here, that it's each residence shall ensure all personnel, so not just direct care workers, but everyone, are vaccinated against other novel pandemic or novel influenza viruses in accordance with guidelines from the Commissioner of Department of Public Health. So, the COVID vaccines are being recommended for healthcare workers, and so, if you read this, seems to be a COVID vaccine mandate for employees at assisted living facilities. The rule also extended to the seasonal flu vaccine, which I think has been sort of in parallel with another mandate from the state regarding students. I'll get to that in a second. But here again, we have what seems to be a very limited approach by the Commonwealth in terms of a targeted workforce that they need to be getting the COVID vaccine. That's a little odd to me. You'd think it'd be a little more broad, but it may well be. It may just be this is the first wave, and we'll be getting a lot of rulemaking that extends the scope of this mandate to other types of healthcare facilities, hospitals, and maybe other industries as well, including, it could be schools again. On the subject of schools, though, this is very topical. This got some media attention in the fall. There was the state Commonwealth mandated that all students in the Commonwealth up to the age of 30, I believe, needed to get a flu vaccine by December 31st. A lawsuit, I think maybe a couple, but at least one lawsuit was filed in October or November that said that the rule was invalid for at least 3 reasons. The first of which was that the department didn't follow the normal rulemaking procedures, therefore it's invalid. Secondly, the rule did not wasn't rational. For instance, there was an exception for homeschooled kids, but not for kids who were learning remotely. And also, I guess there was a constitutional basis or argument that you couldn't extend this rule to university students. So that litigation ensued, and then in December, the department decided to kick back the deadline to February 28 for students to get vaccinated. And then on January 15, they were supposed to file an opposition to their motion for a temporary restraining order. This is last Friday, and the state essentially walked away from the flu vaccine mandate for students, and just said, at least the published reason was that there's no flu epidemic this year, so the feared twindemic hasn't emerged. And so it looks like that case is just going away because the state's saying, oh, never mind, we're pulling the rule. So if you are associated with a university or any school in Massachusetts, this annual flu vaccine mandate is now gone based on what happened last Friday. So again, lots of litigation here, but this to me suggests that this issue is going to be litigated. And so I think it's really important for employers to understand the nuance here in terms of the issues and how it plays out, and to help you weigh whether this is a fight you want to pick. If we can go to the next slide, please. So what is it? This comes down to, can employers mandate COVID-19 vaccine? And again, this issue is so relevant now. Again, the recent media reports relate to a survey of CEOs around the country. And according to this survey that was published just within the last week, 70% of CEOs are inclined to mandate a COVID vaccine for their employees, which is a pretty high number. So when you're asked that question by your CEO, hey, let's mandate can we mandate the COVID vaccine? I'm hopeful that this discussion will give you some information to engage in an informed discussion about the pros and cons of that. And I think the outcome is going to depend highly on your business. This is a very fact-intensive question. So the question is, can employers mandate vaccines, or the COVID vaccine in particular? Yes, maybe. Sorry for that equivocal answer, but I think there's a probable that you can. So why do we think probable? Well, the EEOC published some guidelines about a month ago that I think a lot of employers were happy to see, that it said that employers can mandate a COVID vaccine without running afoul of the ADA. And so why would we start with the ADA? Well, again, a vaccine is a medical procedure, and at least can be looked at as a medical procedure. And so the first question was, well, geez, is administering or making somebody take a vaccine, is that something that is going to be like a medical exam that would otherwise be governed by the ADA, and you can only require a medical exam under certain circumstances? And the answer from the EEOC was no, vaccination is not a medical exam, and you're not prohibited from doing it as long as you don't make any disability inquiries. So the EEOC said, well, if you're going to outsource the vaccine to a third party, like a pharmacy or some other, or rather, primary care providers, essentially the employer says, we don't care where you get your vaccine, just get it, and you've got to show us proof. And if you want to keep working here, you got to come in with proof of your vaccine. So if you've removed yourself as the employer from the actual administration of the vaccine, you're not going to be asking questions that would typically be asked before any medical procedure is performed. Namely, do you have any risk factors? What's your medical status? How are you doing today? That sort of analysis, that sort of examination. And so the EEOC said, if you're not doing that, and if somebody comes back and says, hey, I need, can I maybe just wear a mask for the next 2 months or something like that, and without sort of getting into a dialogue about the person's medical condition, then the EEOC said you're probably on firm ground and you can mandate it. But I think a lot of employers have just seen the headline that said EEOC says employers can mandate COVID vaccines, and they didn't really read the analysis beyond that. So, but what if you're an employer, and if we can move to the next slide. What if you're an employer and you are involved in the vaccination process? Let's say you're a hospital and you're going to administer it right on site, and you're a contractor. So if you engage a contractor to come on site to do your vaccination, or even if it's offsite, if you, the employers, are involved in the selection of the provider, then the knowledge of your contractor is going to be imputed to you, and therefore, to the extent there's a pre-vaccine inquiry about the person's health status, now you're getting into a territory that's governed by the Americans with Disabilities Act. And so if you're going to do that, you can have a medical inquiry, but you need, the bar for doing that is that your purpose has to be job related and consistent with business necessity. What's that mean? Well, the answer is you sort of look at all the factors surrounding the employee's work environment. So the analysis for, let's say, an employee who's a direct healthcare provider is going to be different than someone who maybe works in billing at a remote location, a few towns away. So the purpose of the inquiry has to be job related and consistent with business necessity. The EEOC also says, you have to rely on objective evidence, not just I read somewhere that vaccines are going to protect me from and our employees from getting COVID. So you got to have objective evidence, and the evidence has to show that the employee poses a direct threat to the health or safety of himself or herself or others, like coworkers. And so this is a pretty fact-based analysis here. And so, this is, and if you're in that, well, okay, you've got to look at this everybody's individual situation. And so the EEOC guidance here, I think, is, again, I think a lot of employers are looking at it as a ticket to say, hey, I can do a mandated vaccine. I'm good. The EEOC said so. But I think if you carefully read it, it doesn't quite say that or provide as much protection as many hope. Because as a practical matter, whether you the employer are administering the vaccine yourself, or you're just demanding proof of vaccination and you're not telling people where to get it, somebody comes back and says, I'm not giving you my proof of vaccination, the employer's going to say, well, why not? And the next thing the employee may say is, because I have a medical condition, I'm allergic to peanuts, and I saw all these people have bad, adverse reactions to the vaccine who have food allergies. And look at England, which is that if you have food allergies, then we don't recommend that you get the Pfizer vaccine. So now you're down that path, and you've got to come up with a job-related and consistent with business necessity reason for mandating it. And if we could just next slide. So, so is how do you determine whether an unvaccinated employee is a direct threat to others? So the EEOC guidance actually said that, it's possible that an unvaccinated worker could be a direct threat. But then they also emphasize you've got to do an individualized assessment to assess what's the potential harm. So I think it's worth looking at least as of now, what's the objective evidence that an unvaccinated person is a direct threat to others. So the emergency use authorizations that were applied to the Moderna and Pfizer vaccines, so the only two vaccines right now available in the US, I think the AstraZeneca vaccine is available in the UK, but in the US, it's just the Pfizer and Moderna vaccines. And those EUAs were granted based on a showing that the vaccines reduced moderate to severe COVID-19 symptoms. And if you look at the actual EUA and the statements coming out of the CDC and the FDA and from Dr. Fauci and from the manufacturers, they all say that there's no data that exists currently that shows that these vaccines, either of them, reduces transmission. All right, and transmission is primarily what would be the direct threat of an unvaccinated person, or at least the concern that an unvaccinated person would present or would pose to a vaccinated or other unvaccinated people, like a customer or a patient or a coworker. And if there's no data that exists that either of these vaccines reduces transmission, then it raises the question that maybe an unvaccinated employee doesn't pose any greater threat of transmission than a vaccinated employee, at least based on the current data. And so I think, if this ever gets litigated, the employer is going to have to go through this analysis and say, okay, where's my objective evidence? And they're going to go to the EUAs, and they're going to have a hard time finding it, at least today. And maybe this data will emerge, but it is the reason why, if you read the guidance from the CDC, that they're saying just because you get a vaccine doesn't mean you can stop wearing your mask, stop washing your hands, stop social distancing. So I think some of the questions we're getting from employers is that, somebody gets a vaccine, can I tell them they don't have to wear a mask anymore? Can I have them, interact with clients more because they're vaccinated? And the answer, I'm not sure you can do that, at least not yet. And again, note that these COVID vaccine trials are supposed to go on for 2 years. And the EUAs were granted after only 2 months. So again, I think at this stage, it's pretty, there's more risk, I should say. And it may be that the risk is justified and you're in a business that you perceive, demands that you mandate the vaccines, but I think that's going to be an individualized risk assessment. Next slide, please. So let's say, so we've talked about people with medical issues and going through the assessment of whether somebody poses an objective risk to third parties or themselves. So what if you have an employee who refuses the COVID vaccine and it's just for their personal reasons? They don't have a medical issue or religious issue, which we'll talk about in a few minutes. And so, shouldn't we have a green light? And they're employees at will. And if somebody says, I don't want to get it because I just don't want to get it, then you should be able to fire them, right? And the answer is maybe, probably yes. But this is a situation where there's a potential for what we call the public policy exception to the at-will doctrine could apply. And the public policy exception basically says employers can't terminate employees if it would violate a doctrine of public policy or state law or federal law. So, well, what are we talking about for state law or federal law? Well, the federal regulations that are issued by the FDA that govern EUAs, emergency use authorizations, they expressly say that people have a right to refuse what they call unapproved medical products that are authorized under an EUA. So, and otherwise the EUA may not have been granted if there was a prospect that people would be forced to use these unapproved medical products. And so both the Pfizer and Moderna vaccines, which are not licensed, again, these are pre-licensed EUAs, can you mandate that on somebody as a condition of employment? So I don't know the answer to that. It's a very interesting question. And when lawyers say it's an interesting question, you should be worried that, we don't have confidence in how this would turn out. And if you want to press the issue, then you may be the test case. And it's likely that maybe you don't want to be the test case. But Massachusetts has recognized the possibility of a public policy exception to employment at will. So for instance, there's at least one case that said you can't fire somebody for consulting a lawyer about employment issues. There's no law that expressly prohibits that, but there's a public policy that encourages the ability of people to get legal advice. So again, that's case law sparse on this. And I think once the vaccines get licensed, this analysis would change, I think, and very likely would give the employer a lot more latitude. But until that happens, I think under an EUA, I think there's a significant amount of risk associated with mandating vaccines if this were to be challenged. Next. So we've got some additional issues, and boy, yeah, there's just so many issues that come up with these vaccine mandates. But Tawny's going to talk about this next round.
Yeah, so Rob did a great job of kind of giving people the background about what we know to date, what the CDC is saying, what the EOC has specifically told us. Outside of that, there's a host of other things that employers need to be keeping at top of mind if they are considering the possibility of mandating vaccines for COVID-19. The first one is religious exemptions. So
looks like we've got a sound issue with Tawny. So on religious exemptions, I'll just sort of take over while Tawny's frozen. But religious exemptions exist in parallel to disability laws, and essentially the analysis is quite similar. That if somebody says, "I have a religious belief that that is inconsistent with me taking a vaccine," let's say it's a Christian Scientist or a Jehovah's Witness, or somebody who is has some other religious belief, then that's held sincerely and it's for ethical or moral beliefs. Then you have to try to find an accommodation, a reasonable accommodation. So if somebody's of certain faith that they pray on Saturdays, and can you give them a day off on Saturday? That's sort of a yes or no. Maybe you can. But that's sort of a typical accommodation question that comes up with religious accommodations, but it could come up as well here. It's also important to note that the religious exemption doesn't apply just to the recognized, organized religions, Catholicism, Protestantism, Islam, Judaism. It's anything. It could be, just has to be sincerely held religious, ethical, or moral beliefs. So it's pretty broad. And, is it as broad as, well, I think my body's a temple and therefore I'm a church of one? Maybe, maybe not. I know that, this religious exemption was litigated within the last year or two against a hospital in Massachusetts over the flu vaccine. And I know the hospital successfully beat back that religious discrimination claim. But I think the basis for the outcome turned largely on the fact that the employee just was refusing to wear a mask. They said, you can't, all right, as a religious accommodation, we're not going to make you get the flu vaccine, but you got to wear a mask from October till April. And she just flouted that expectation. So anyway, that's another issue. Religious exemptions. If you're a unionized employer, mandatory vaccination would be a mandatory subject of bargaining. So you've got to be pretty careful if you have a union environment. If you don't have a union, well, you still have an issue here because you may have a negative impact on morale with such a high percentage of the population, at least 25% right now, saying they're not going to get a vaccine. You can expect that there may be some pushback from employees if they're told they have to get one, or even if it's strongly encouraged. Let's say you give you give bonuses to people who get the vaccine. The people who don't get the vaccine are saying, well, how come I'm not getting that money? That's not fair. And so you may have employees who band together and say, hey, we think this is not fair. We're not going to get it. And that's the kind of activity that's expressly protected by the National Labor Relations Act. That's collective concerted activity of two or more employees band together on items of mutual concern about the terms and conditions of employment. Then that's going to be protected. So, and if you retaliate against them, you'll get a charge at the NLRB. And so we'll be spending some time together down at the NLRB's office, or right next to the garden. So that's union issues, morale issues. Employees may quit if they're made to get a vaccine that they don't want to get, and they'll find another employer. And if you're in healthcare, especially in assisted living or long-term care, staffing is tight, and you may not be able to afford losing even 5% or 10% of your workforce because you're applying a mandate that other employers don't. So that's another issue. OSHA retaliation issues. It could be a workplace safety issue. Let's say with that scenario out of San Diego last week where the healthcare workers, there was a string of them, maybe at least half a dozen to up to 10 who had allergic reactions. And let's say the 11th person in line said, I'm not getting that vaccine, looking at, 7 or 8 people in front of them having anaphylactic reactions. That employee says, I'm not going to do that. They're now in a protected category under OSHA. They're talking about a workplace safety issue. And so you'd be mindful not to discriminate against them or retaliate against them because they've expressed a workplace safety concern. So I think Tawny may be coming back on, but I'll keep talking as it relates to the next one, which is workers' comp. And this is a really interesting aspect of this. So with workers' comp, is this a work-related injury if somebody has a bad reaction? And the answer is maybe. If it's mandatory, probably it's workers' comp. If it's not, if it's a voluntary vaccine and it results in an injury, then it's probably not covered by workers' comp. Tawny, are you back on? Okay, well, I'll keep talking about workers' comp. So with respect to the workers' comp aspect of this, then I think we're hearing some inconsistent things. Some workers' comp carriers are strongly suggesting to their insurers that they don't mandate vaccines, that they only make it voluntary, and that may be a good risk management and advice, but it also means that the risk of a workers' comp claim goes way down if it's a voluntary vaccine. But if you mandate it, then it's arguably covered. But of course, that actually raises another question: is who's liable if there's a vaccine injury? Who can get sued? And we've seen early litigation in COVID is that a lot of employees are suing employers for getting COVID because the employer didn't, as they allege, didn't do enough to prevent them from getting COVID. Like you're seeing these cases coming out of the meatpacking plants in the Midwest, and where people got COVID and some of them tragically died. Their families are suing the employers, and the employers are putting up a workers' comp preemption defense saying, hey, your only remedies before the Workers' Compensation Board of the state, and your remedies, whatever the Workers' Comp Act gives you. And the plaintiffs' lawyers are saying, no, we want to go around that. We're not barred. We're going to sue you, the employer. So could a similar claim be made against an employer for mandating a vaccine, maybe by overreaching? They didn't have the objective evidence, maybe, because if you're a plaintiff's lawyer, you've got a bad outcome, like let's say that doctor's family in Florida who tragically died a couple weeks ago after getting the Pfizer vaccine. That's a potentially big money claim, and so who's liable? Let's say the vaccine was a bad batch. Can they sue the vaccine manufacturer? The answer is no. There's no liability for the manufacturers or for the doctors or other healthcare providers who administered that vaccine under the PrEP Act, which is a federal statute. So the only one left standing without protection is arguably the employer. So I think Tawny may be back on. Can you hear me, Tawny?
My apology. Yes, my apologies, everyone. The power company just knocked on our door to tell us that we will be out of power for the next 3 hours. So I apologize if there are any issues or cutouts right now. We're working on getting back up, but with hope I'm going to have some form of internet connection for the foreseeable future. So if we can move on to the next slide.
I think we're on to independent contractors.
Perfect. So many of you might have noticed that in the last few weeks, you've seen a plethora of news stories that have been discussing the Trump administration's changes to the independent contractor rules. Specifically, the administration had proposed changing longstanding rules that had been in effect to create what's called the economic reality test. And in doing so, what the administration was attempting to do was that they were going to make it easier for employers to employ independent contractors. And the court and federal Department of Labor would look at two core factors. One, the nature and degree of the worker's control over the work. And second, the worker's opportunity for profit or loss based off of initiative or investment. And you might be saying, Verrill, why didn't you update us on this? Are we just hearing about it now? And the reason is because we already had knowledge that the Biden administration was going to revoke this rulemaking. Specifically, the Biden administration has stated that the Department of Labor will use what's known as the ABC test. And the ABC test is likely well known to all of our Massachusetts clients, as it is the test that is currently used under the Commonwealth's standard from the Commonwealth Department of Labor. So specifically, when we're looking at the ABC test, we're going to analyze whether or not the worker is free from control and direction in their work, both under a contract and the terms of the contract and in fact. We're additionally going to look at whether the work performed outside the usual course of the employer's business. And then finally, if the worker is customarily engaged in an independently established business, occupation, or trade. Now, we have a multitude of guidance from the Massachusetts Office of the Attorney General on specifically whether or not the work is outside the usual course of business. And what we've gotten from the advisory opinions from the Attorney General is that it's going to be nearly impossible for an employer to use an independent contractor to do the same type of work that the employer already is performing. So employees should keep that in mind. If you have a discrete need, you're not going to be using an independent contractor if that discrete need is the same or within the realm of the work that you already do as an employer. If it is outside of your normal work, then potentially using the ABC test, you're going to be able to analyze whether or not an independent contractor is appropriately used. Going to go to the next slide. The next thing we're going to talk about, and there's limitations here. The Supreme Court didn't have a ton of updates in 2020 that relate specifically to labor and employment outside of the benefit realm. But I'm going to turn it over to Rob for him to give you some background about the biggest case and decision that the Supreme Court entered in 2020.
I think the biggest decision that came out of the Supreme Court this last year was the Bostock versus Clayton County, Georgia decision. And this is a landmark case for gay and transgender rights. And what the Supreme Court did was they finally resolved a split among the circuit courts of appeal, and also sort of a disjointed disconnect with longstanding sort of federal administrative agency divides over whether people who are gay and transgender are protected under Title VII of the Civil Rights Act. Namely, is the phrase "based on sex." Does that apply to people who are gay or transgender? And for many years, federal courts have said no. That process has, or that conclusion has evolved over years until we get to a split. And many state courts and state laws explicitly extend that kind of protection for discrimination based on sex to people who are gay and transgender. So we've had this disconnect, and finally the Bostock case resolved that, and now it harmonized. And Justice Gorsuch, who wrote the opinion, has basically made the point that you really can't peel out of someone being homosexual or transgender from sex. And so he says he used anyway a very textual analysis, which is his philosophical bent, to come up with that conclusion. It was a 6-3 opinion, so there was a dissent, of course. But still, I think this is good news. Harmonized law is always better for employers, makes things more predictable when you're running your business. But there's some interesting implications, one of which, if you're a religious organization, this ruling may make you feel you have less protection now if your organization has certain tenets that view people who are gay or transgender differently. But there are some ministerial exemptions that to the Title VII that I think still apply, and that this court, I think, would very likely recognize it. Question about housing. Let's say you're Title IX, if you're a college or university or other school, you decided to room a transgender female with another female resident. Not going to cause a problem, meaning because you have to sort of accept the transgender female's declared status. Maybe not. I think that person arguably has some additional rights to say you have to treat me like a female. Let's say you're a religious affiliated college. I'm not sure. How about the transgender female with a male resident? How would that be viewed? Also, healthcare, Title VII. Does that now prohibit an insurer from declining coverage for sex reassignment surgery? I think that's something that has been declined by many carriers in the past. This decision probably makes that harder. And so those are some of the unresolved issues from the Bostock case. Stay tuned. I'll turn it back to Tawny for the next.
And that's the only case we have a decision on. So what I'm going to talk about are two cases that are currently pending before the Supreme Court. So the first one is Henry Schein versus Archer and White Sales, Inc. And that was argued before the Supreme Court on December 8th of 2020. It's on appeal from the Fifth Circuit Court of Appeals. And the issue before the court is whether a provision in an arbitration agreement that exempts claim from arbitration, whether or not that is a determination to be made by an arbitrator or the court. So it seems like a really technical kind of legal question, but it's going to have broad-reaching legal implications because it's reviewing the scope of the Federal Arbitration Act. And the two companies involved, it's an argument regarding a contract concerning dental equipment specifically, but what we're looking at is whether a court decides what's going to be arbitrated or whether an arbitrator decides what's going to be arbitrated, which if it's a court, could potentially increase the costs associated with arbitrating a matter and decrease a lot of the advantages that potentially are in play when we're talking about arbitration agreements. The second case is Van Buren versus United States. And that was argued before the Supreme Court on November 30th of 2020. And it's on appeal from the 11th Circuit. And the issue before the court is whether a person who is authorized to access information on a computer for a certain purpose violates the Computer Fraud and Abuse Act if the individual accesses the same information for an improper purpose. So for our friends and clients who currently have in effect some form of proprietary contracts, confidentiality agreements, non-solicitation agreements, should you ever discover that a current employee or a former employee is sharing proprietary or confidential information, oftentimes we'll look not only at your contractual rights as a result and whether or not you have a cause of action against that current or former employee, but we also, in most cases, will look to the Computer Fraud and Abuse Act to see what potential causes of action are available. This ruling is going to expand potentially an employer's cause of action under that statute more generally. Rob, anything to add from that perspective? Okay, we're going to go to the next slide.
Keep going.
So what I'm sure all of you have been dealing with recently, the Massachusetts Paid Family and Medical Leave Act. So we know we had a lot of work was done with this in 2019 when we were getting prepared to start making the financial contributions to the state and informing employees of kind of what this new statute provided and what their obligations were under it and what the benefits were. We're now at a place where as of January 1st, we know that eligible employees were able to begin taking leave under the statute, and specifically covered workers who had a serious health condition that was incapacitating them from work were entitled to 20 weeks of medical leave under the statute. And this plays a role with COVID. So consider if COVID is a serious health condition, and that's a determination that we're going to be getting clarity on from the Family Medical Leave Act, Paid Family Medical Leave Act Commission probably soon, and seeing more of those cases. We know that covered workers may be entitled to up to 12 weeks of family leave within a year for the birth, adoption, foster care, placement of a child, or because of a qualifying exigency arising under a family member's deployment with the armed forces. We know that a covered worker may be entitled to 26 weeks of family leave as a result of a serious health condition of a covered service member. Now, beginning on July 1st of 2021, so in 6 months, that's when the final two provisions will take effect. And that's the 12 weeks of family leave to care for a family member with a serious health condition, and then the 26 total weeks in a benefit year for partial wage replacement as a result of self-employed individuals. So those are things that should be kept at top of mind from the Paid Family Medical Leave Act. And we still have a handful more slides, so we're going to move on to one of the bigger cases that was decided in Massachusetts in 2020. And we didn't see a plethora of labor and employment decisions from the Supreme Court that are important to note. But one of the big ones was this case, Parker versus Enternock. And in that case, the plaintiff was a senior sales manager who was salary plus a commission. And before the termination, the plaintiff had earned a commission that was going to be paid in 2 installments. So first at the contract formation, half of it would be provided. And then 1 year after formation of the contract, If the contract was still in existence, the second part of that commission would pay. The question before the court was the definition of wages and whether or not this commission constituted lost wages under Massachusetts Wage Act. And the court indicated that it did. And the court specifically looked to see if the commission was definitively determined and due and payable. And if those three standards were met, the court indicated that it would be considered lost wages under the Wage Act. So important to note from a wage and hour perspective, especially for those of you who use bonuses or commissions in some format, if it's definitively determined, if it's due and payable, those three are going to be looked at to determine whether or not it constitutes Wage Act. Additionally, we saw a decision in October in which the Supreme Court held that a workers' compensation insurer did not have to reimburse an insured party's claim for medical marijuana. So I know in the past, if you've attended our annual update, you've heard from Beth Smith with discussions about the implications of medical marijuana from a workers' comp claim. It was nice to get some clarity in 2020 from Massachusetts as to this factor. Let's jump to the next slide. And Rob, do you want to talk a little bit about Families First Coronavirus Response Act and President Biden's reenactment?
We've got a few minutes left in our presentation. And so many of you would be covered by the Families First Coronavirus Response Act, which was signed by former President Trump in March of last year. Essentially, that offered paid leave for people who had a qualifying reason, like they were in quarantine for COVID, or they had certain childcare responsibilities because their child's school or daycare was closed. And so that law was set to expire on December 31st. However, it was extended, or at least parts of it were extended just a few weeks ago to essentially allow employers to continue to offer the paid leave. They're not mandated to do it, but they're allowed to do it, and they still get the tax credit. And so that extension is now running through March 31st, 2021. So to the extent that there was any employees who still had unused paid time off eligible, again, this is for covered employers, so employers with fewer than 500 employees, and for otherwise eligible employees, as defined by the statute, these employees can request some paid time off, and the employer can give it and get the tax credit at least through March 31st. The board, the National Labor Relations Board, deals with union issues. The federal agency, President Biden ran on the campaign that he's going to be a very pro-union president. He's going to have a union member in the White House. I think Dr. Biden is a member of the teachers union. And so President Biden didn't waste any time yesterday to sort of follow through on that promise. And he is reported to have called for the resignation of the board's general counsel, Peter Robb. And that's a fairly unusual move by a new president. Typically, the general counsel sort of runs the administrative part of the board, and they also have a large prosecutorial function. They run the cases that the board is litigating. And the practice for the last 70 years since the Truman administration has been to allow the incumbent GC's term to expire. And former President Trump allowed the last GC, who was Dick Griffin, who was the general counsel for the operators union. Those are the people who run the cranes and whatnot. He let Griffin's term expire, but Biden wasted no time, and GC Robb, general counsel Robb, is very likely going to resign and go out the door. So this signals a pretty swift end to the last 3.5, 4 years of a relatively pro-management era. So if you have a union, brace yourself for a more union-friendly board. And if you don't have a union, I think you should prepare for more union activity. This may be the time to kind of assess whether you are vulnerable to union organizing, this is going to be a fairly pro-union environment, at least in the administrative level. So I think that's what we've got on that. And Tawny, new executive orders again. The developments are coming out of the woodwork. Can't keep up.
So not included on your slides, but two things that are important to take note of, which are literally, I think Rod and I have multiple screens going because we're just refreshing to see what's happened. Probably not the best day to hold the annual update the day after the inauguration, but important things to know. Biden yesterday signed the executive order on advancing racial equity and support for underserved communities through the federal government. And what this executive order does is it revokes the September 22nd, 2020 executive order that applied to all federal contractors entitled Combating Race and Sex Stereotyping. For those of you who have federal contracts, you'll remember that this is the order that provided that you needed to stop any form of bias training, which may make individuals feel uncomfortable regarding their background or historical events that have happened concerning race or sex. And then additionally, yesterday, Biden signed executive order on preventing and combating discrimination on the basis of gender identity, sexual orientation. And what this does is he has mandated that in consultation with the Attorney General, that each of the agencies within the federal government review its policies and practices to make sure that they are in compliance with Title VII and any other statute or regulation that may prohibit sex discrimination. And really the purpose of this is to bring the federal government in compliance with the Supreme Court's decision that Rob discussed earlier. So we're a minute over, so I apologize for that, but thank you all so much for your attention. We appreciate it. I sincerely apologize for leaving you all for a few moments, but